and its people from the further harm. Moreover, demonstrating full respect for international law, the Republic of UNSZA reported its action to the Security Council immediately after initiating defensive operations, thereby fulfilling its obligations under Article 51. The importance of such reporting was emphasized in the ICJ's judgment in the Congo against Uganda case. In light of this consideration, we respectfully submit to this esteemed court that the Republic of UNSZA has acted within its legal rights under international law. Specifically, it exercised its rights to self-defense as provided under Article 51 of the United Nations Charter in response to the armed attack it suffered. Allow me to now direct your attention to our second point, Your Excellencies, that is the lawful targeting of objects by the Republic of UNSZA during the unfortunate conflict. In accordance with Article 52, Clause 2 of the Additional Protocol 1 to the Geneva Conventions, attacks during an armed conflict must be strictly limited to military objectives. As defined, these military objectives can be referred to their nature, location, purpose, or used to make an effective contribution to military action. In the midst of this conflict, the Republic of UNSZA, being respectful of international law, targeted its actions towards critical infrastructures, power plants, transportation networks, and command control centers. As evidence on the page 11 of our Moot problem, all these targets were chosen meticulously, aimed at disabling of the United Provinces of Rosanna's military potential while ensuring minimum harm to the civilian population. Contrary to the assertion that these actions have deprived the civilian population of indispensable objects for survival, as prohibited by Article 14 Additional Protocol, we submit that none of the basic necessities were affected by these operations. The attacks were precision-based, deployed strategically to incapacitate military capabilities while leaving civilian life untouched. Your Excellencies, I draw your attention to the case of the legality of the threat or use of nuclear weapon, where it was affirmed that the principles of proportionality are integral parts of the international customary law. It's important that to distinguish between the principal use of nuclear technology and the development of nuclear weapons. Even though it is recognized under NPT, but it does not extend to the question of weapon in mass destruction. For instance, you can see in the case of North Korea, United Nations Security Council has imposed several rounds of sanctions on North Korea due to repeated testing of nuclear weapons and ballistic missiles. In light of this, the Republic of UNSZA actions have been within the bounds of legality and necessity undertaken to protect its sovereignty and its people. In summary, we respectfully submit that the Republic of UNSZA has adhered to international law, targeting only lawful objects and maintaining a strict adherence to the principles of proportionality. Moving to our last point, Your Excellencies, the Republic of UNSZA submits that it is not liable to pay reparations, as stipulated in Article 31 of the Articles on the Responsibility of States for International Wrongful Acts. The reparations are due when there is a breach of an international obligation. UNSZA acted with its legal rights under Article 51 of the UN Charter in self-defense to an armed attack by Rosanna. This fact alone negates any assertion of wrongdoing on UNSZA's part and thereby removes any legal foundation for reparations. Furthermore, the causation, as per Article 31 of the aforementioned articles, between UNSZA's actions and the alleged damage is not clear. The burden of proof lies with Rosanna to demonstrate this causal link, which it has failed to do. The Kofu China case established the necessity of such proof. Therefore, without clear evidence of causation, there is no legal basis for UNSZA's obligation to pay for reparations. Therefore, we submit that the Republic of UNSZA acted in accordance with international law by launching military attacks against United Provinces of Rosanna and need not pay reparations for the damage.
Sorry, Counsel. Your argument is UNSZA acted in self-defense.
Yes.
Is that correct?
Yes, yes.
But Rosanna didn't take any action or didn't attack UNSZA in the first place. So what self-defense there is? They are just developing a military, weapon, which they say is for their own defense. They didn't even launch an attack on you. So what is the self-defense you're talking about?
To answer your question, Your Honor, Azura had to act promptly and decisively to neutralize the threat and prevent further attacks from the Rosanna, because Rosanna uses hypersonic missile. So Azura had to neutralize the threat immediately, meaning
So
that
the time they are just developing the weapon, right? They have not launched the weapon on your country, your client's country. So it's just your client getting worried and then launch an attack first on Rosanna, isn't it?
To answer your question, Your Excellency, intelligence reports report that new technology possessed by the Rosanna had the capability of of carrying multiple warheads, each with destructive power for uh, exceeding as a dangerous weapon.
Yeah, but what is the evidence that says that they are targeting Azura, and Azura is actually under threat of Rosanna because of they are just developing this weapon, and that prompted any or gave any perceived threat that Azura needs to attack first? I don't see any evidence. You haven't pointed me to any evidence.
The evidence can be seen in the page 9 and 15. It's stated that in article under article 51, it requires that the force used in self-defense must not exceed what is necessary to stop or prevent the attack. In this instance, Your Honor, Azura responded to the nuclear strike development in a manner that was designed to neutralize the immediate threat and to prevent further attacks from Rosanna. The response was proportionate as to the initial armed attack, as it aimed to stop the ongoing aggression and preventing the further harm. Does that?
No, I still don't understand because Rosanna was just developing that weapon. Rosanna did not launch the weapon on you. Your country has a perceived threat. You think that there's a threat there, and then you launch an attack first on Rosanna. Yeah, I get the facts correct. Is that correct?
Yes, Your Honor.
So my question is, just because somebody is developing a weapon, how does that create a threat to you? Where do you get that sense that, oh, I need to stop that? It is targeting me. And therefore you need to self-defense, because they are developing their weapon. Their statements say that they're developing their weapon for themselves, not to attack you. Then where do you feel the threat for that you need to self-defend?
Your Honor, may I take a moment? May I have a moment, please, to
Sure.
process the information?
I understand you want to say that it is proportionate and things like that, but why did you attack first when they didn't attack you? How can it be said to be self-defense? Is there any case law? Is there anything that can explain the situation?
1 minute left.
Apologies, I do not have the information, uh, full information for that. May I proceed with the next point?
Okay, sure. You're muted, I think.
Okay. Therefore, we submit that United Provinces of Lausanne violated international law in targeting Octagon with its hypersonic nuclear missile and must pay reparations to Republic of Azra for the damage suffered. Thank you for your attention, Your Excellencies. I stand ready to answer any queries that you have. If there are no further questions by the floor, I will end my submission here, and my co-counsel shall proceed with the second issue.
Okay, thank you, Council. Next.
May it please the Court, Your Excellencies.
May it please the Court, Your Excellencies. My name is Risha Zulkifli as the co-counsel. We'll continue with the second issue in which we submit that United Provinces of Roxana violated international law in targeting Octagon with its hypersonic nuclear missile and must pay reparation to Republic of Azra for the damage suffered based on three contentions. First, it is wrongful to use nuclear weapons. Second, Octagon is not a military object. Third, Roxana is responsible to restore the damage that suffered by Republic of Azra. Your Excellencies, our first contention is regarding the environmental consequences of the nuclear weapon launch. Article 31 and Article 55 of the Additional Protocol 1 to the Geneva Convention explicitly prohibits methods of warfare that are intended to cause severe damage to the natural environment. The launch of the hypersonic nuclear missile by Roxana, which released a large amount of pollutants in the atmosphere, falls under this prohibition. Thus, we submit that Roxana has violated its international legal obligation, especially related to the prohibition of causing widespread and severe environmental damage during the warfare. In the light of this consideration, we respectfully urge the Court to find that the United Provinces of Roxana, in violation of its obligation under international humanitarian law for causing severe environmental damage for breaching this principle of distinction. Your Excellencies, as for our second contention, we maintain that Octagon is not a military object and that the United Provinces of Roxana's attack on it contravenes international law. We turn to our first status of Octagon. Article 52 of Additional Protocol 1 to the Geneva Conventions of 1949 provides that the definition of military object. Roxana attacked Octagon with a hypersonic nuclear missile, asserting that it was a military object. However, there is no indication that Octagon was being used for any military purpose or that it was of a definite military advantage to Azra. This echoes the jurisprudence of the case in prosecutor against Dusko Tade, which clarified certain aspects that we can be considered as military objects. Article 81 of the Protocol 1 considered making the civilian population or individual civilians not taking part in hostilities the object of an attack, a grave breach of the protocol. In this case, Octagon contributed nothing to military action. Given this consideration, we respectfully request the Court to find that United Provinces of Roxana has breached the international humanitarian law by attacking a non-military object, causing a civilian casualty, and resulting in a grave breach of the Geneva Convention. Your Excellencies, as for our last contention, we wish to argue that United Provinces of Roxana is under a duty to restore the damage that has been suffered by the Republic of Azra. We start by referring to the fundamental principle of international law, which persists that a responsible state has a duty to provide complete compensation for the harm resulting from the internationally wrongful act. This is stated in Article 31 of the Articles on the Responsibility of States for Internationally Wrongful Acts 2001, which provides that the responsible
Council.
state is under.
Sorry,
Your
Council, I interrupt you for the time being. I just want to go back to the previous point. Isn't the Octagon the command center, military command center for Azura?
It's not a military command for Azura. It's the metropolitan and the capital city of Azura.
Is it? Can you point me to the fact that says there?
Your Excellencies, I refer you to the. May I have a moment, please?
Sure. I just want to clarify because I'm looking at paragraph 30. It says that the missile was launched with a specific target in mind, Octagon, Republic of Azura's military command and control center. Is it saying that that statement is wrong?
Which would be?
I know Octagon is in the capital. I know there are civilians that may be affected when you launch at the capital. But is it not true that Octagon is the military command center?
Yes, Your Excellency. To answer your question, it is a military command center, but it is not the main base for Azura's military center.
But if I target the military command center of my enemy, where they use the center to control the military, how is that not a military object? Shouldn't I be? I mean, I think it's a smart thing to target an enemy's military command center to stop their military action against me.
Your Excellency, to answer your question, Octagon is lived by 8 million of civilians in that case. So, Roxana attacked 8 million or threatened 8 million of civilians in that place. So we cannot consider this as proportionate to what Azura has been done before.
No, but that is a proportionality. There's not a that's proportionality question. My question is on the military object. You say that targeting the Octagon is not a military object, but now we know that the Octagon is the military command center, and targeting an opponent's and an enemy's military command center, isn't that exactly a military object? Yes, there may be civilians affected, but at least that element is fulfilled.
Your Excellency, to answer your question, according to the Article 52 of Additional Protocol 1 to the Geneva Convention, this provision defines military objectives as objects which by nature, location, purpose, or make it effective contribution to military action. Since I mentioned before, this Octagon lived by 8 million of civilians. So, by attacking the Octagon, Roxana is threatening 8 million of citizens' lives. Does that answer your question?
Not, I mean, I can understand that you are not allowed to target civilians, okay? But you can target a military object. In this case, the Octagon seems to me like a military object, even though it affects civilians. So that is my question that I still hope to be able to resolve.
Your Excellency, to answer your question, yes, it is true. The Octagon is the military object, but if you refer to the Article 52 of the Additional Protocol 1, this falls under the exception since the location is lived by the 8 million of the citizens. So, by Roxana attacking the Octagon, this will threaten the 8 million of 8 million life of the citizens, and this has breached the humanitarian law as stated in the United Nations Charter.
So you say that there's a law that says that there's a provision that says that it can be a military object, but if there's too many civilians being there, it can be an exempted from being considered a military object.
Yes, Your Honor. It's stated in Article 52, Clause 2 of the Additional Protocol 1 to the Geneva Convention.
Okay, proceed.
May I proceed? Thank you, Your Excellency. As for our second contention, we maintain that octagon is not a military object. So, may I proceed with my third contention?
Yeah.
Thank you. Your Excellencies, as for our last contention, we wish to argue that the United Provinces of Roxana is under a duty to restore the damage that has been suffered by the Republic of Azura. We start by referring to the fundamental principle of international law, which states that a responsible state has a duty to provide complete compensation for the harm resulting from the internationally wrongful act. This is stated in Article 31 of the Articles on the Responsibility of States for Internationally Wrongful Act 2001, which provides that the responsible state is under obligation to make full reparation for the injury caused by the internationally wrongful act. The significance of this principle has been underscored in the landmark cases such as Germany against Poland, where the International Court of Justice held that the obligation of a state to make full reparation for an internationally wrongful act was integral to the fulfillment of its international responsibilities. In light of this consideration, we respectfully urge that the court to find that Roxana is obliged to provide full reparation to Azura for the harm caused by its internationally wrongful act. Therefore, we submit that the
Counsel,
United Provinces of Roxana.
Counsel,
Yes, Your Excellency.
Counsel, am I audible to you? Counsel, you stated that you need reparation for this. Would you please specify in what form do you require reparation and as what law we are required to give you the reparation? I
Sorry, Your
please
Excellency.
elaborate
Could
on
you
that.
repeat, please? Sorry, Excellencies, could you repeat your question? Because I cannot
Yes.
hear you clearly.
Yes, yes, yes. Yes. Can you hear me now?
No. Sorry, Your Excellency.
Am I audible to you now?
Yes, Your Excellency. Your Excellencies, could you repeat your question before?
Okay, Council 2, you may proceed.
Thank you.
Just has some issue. Okay, thank you.
Okay. Your Excellencies, therefore, we submit that United Provinces of Roxana violated international law in targeting Octagon with its hypersonic nuclear missile and must pay reparation to Republic of Azura for the damage suffered. Thank you for your attention, Your Excellencies. I stand ready to answer any queries you may have.
Okay. How about the point on they are just acting in self-defense because you launch an attack against them first. So they have to stop the escalating attack on them, they have to launch a missile. So in fact, you should be the one paying them because you started the war.
Answer the question. May I, the second counsel, answer the question, Your Honor?
Yeah, this it's still your session. You answer the question.
Your Excellencies, to answer your question, according to Article 2 of the Non-Proliferation of Nuclear Weapon, it is stated that development of nuclear weapon is prohibited. So as per Roxana case, they have developed an unlawful weapon whereby it is unlawful to develop a nuclear weapon. In this case, if we refer to the clarification number 10, it says that the nuclear weapon will utilize or will damage the environmental issues. So therefore, Azura attacked the military base in order to paralyze their military research. And to add on more info about that, Azura did not make any casualties to Roxana. They just damaged the military infrastructure in order to paralyze their military research. Does that answer your question, Your Excellency?
No, I mean that answers the question that I had earlier for your lead counsel. But my question to you is that when they attack you with the nuclear missile, they are also retaliating against you or self-defense against the attack you have on them. That's the only reason why they actually launch an attack, because previously they did not launch an attack on you first. You attack them first, they have to self-defend. So how then should we say that they should be giving you a reparation when they are just acting in self-defense triggered by you?
Your Excellency, if you would like to ask for extension of time in about 2 minutes.
Yeah, sure.
Your Excellency, to answer your question, it is regrettable that Roxana must bear with the brunt of damages. However, international law principles of break it, you fix it applies primarily to wrongful action. In this case, Azra was exercising its legal right to self-defense. It was Roxana's illicit development of use of nuclear weapons that broke international law and provoked the conflict. Consequently, Azra should not have financially liable for Roxana action, which led to this unfortunate event. Which means that the Roxana, by developing the nuclear weapon, it is considered as a provocation to Azura. I hope my
Okay.
answer satisfies.
Not really, but okay. You can wrap up. I mean, unless other judges, you have any other questions? I think just now the question that it's trying to, my learned sister trying to ask is on what specific terms that you can seek for reparation. Maybe you can assist on based on what maybe rule or law that you can seek a reparation from the other side. I'm sorry, I may not get the correct question, but yeah, can you please address that?
Your Excellency, to answer your question, if I believe that your question is, I'm sorry, could you repeat your question again?
Can you specify specifically under which rule that you may seek a reparation from the other side, and in what terms, what kind of reparation that you're seeking from the other side? Just answer that question and then you can close.
Okay. Your Excellencies, we would like to extend our answer for maybe 30 seconds. Is it possible?
just answer the question. Yes, please.
All right. According to Article 35 and 55 of the Additional Protocol 1 to the Geneva Convention, it says that the state that makes a damage to another state must pay full reparation to the country that it suffered damage. So I hope that answer your question, Your Excellency.
So it will be in the form of monetary compensation.
Yes, according to the principles of fairness and equity, yes, it should be a compensation in terms of monetary.
Okay. Okay, thank you. I'm sorry, the other
Thank you,
Judge Marlon sisters, the internet issue. But yeah, I think we can proceed.
Thank you.
The respondent team can begin their submission.
Hello, am I audible?
Yes.
Okay, thank you so much. Uh, First, before we begin, we would like to apologize that we cannot apply a background to our meeting today because there is no we cannot apply it.
All right.
Thank you so much. Good morning, Mr. President, Your Excellencies, may it please the court. My name is Muhammad Aksana Diatma Amir, and I have the honor to appear on behalf of the provinces of Roxana, the respondent in today's proceedings. I will speak for 16 minutes, and my co-agent, Mr. Nazal Amin Firdaus, will speak for 17 minutes. And with your permission, we'll reserve 2 minutes for rebuttal. Your Excellencies, over the course of the next 35 minutes, we will expound further on the first and second argument pertaining Republic of Azura violated international law by launching military attacks against United Provinces of Roxana and must pay reparation for the damage suffered. Meanwhile, my co-agent will explain the final submission. If Your Excellencies has no preliminary inquiries, we will proceed with our first submission. Your Excellencies, Republic of Azura multi-pronged attacks to the respondent states cannot be justified as a self-defense, and it is a violation to international law. In today's pleading, we submit two major arguments. First, Republic of Azura is violating international law by launching its military attacks towards provinces of Roxana. And secondly, Republic of Azura must pay for reparation for the damage suffered. Entering our first major argument, the African state military attacks are not in accordance to international law for four reasons. First, the attack constitutes act of aggression. In Article 2, Paragraph 4 of the United Nations Charter, it is stated that any states shall refrain themselves in their international relations from the threat and use of force against the territorial integrity of political independence of any state or in any other matter consistent with the purpose of United Nations. It is also stipulated in UNGA Resolution 3314, which is defined the act of aggression. Here, the applicant state actions was not in line with the principle of non-use of force. This principle is recognized as a customary international law, and it is opinio juris. In the case of military and paramilitary activities in and against Nicaragua in 1986, United States attacks using military forces against Nicaragua territory was unjustifiable. And according to Article 3, Article 3.d of the UNGA Resolution 3314, stated that an attack by the armed forces of a state on the land, sea, or air forces or marine and air fleet of another state is qualified as an act of aggression. In this case, Azura violated this principle for using its military forces to attack the respondent state territory and utilizing its land, air, naval fleet, resulting in a widespread destruction. Republic of Azura also violates the principle of non-intervention. It is prohibited to intervene directly or indirectly with or without armed forces. In the Congo case, it is proven that Uganda intervening the Congo territory a violation to, and it is a violation to this principle. Here, Azura's action on attacking and intervening with Roxana's internal affairs is a violation to international law.
Well, I
May
mean,
please-
I think we know that it's an act of aggression or there's an attack on Rosanna. But the problem is that they're saying it's doing for self-defense. So I think you should address whether it is self-defense or not.
we cannot justify the argument of self-defense submitted by the applicant state, Your Excellency. May
Sorry,
I
what?
proceed? Even though the applicant state submitted that they are engaging their right to exercise the self-defense. However, the self-defense exercise by the applicant state is not justifiable. Excellency.
Yeah, why? Why exactly? Why do you say it's not self-defense?
May I explain this in my further argument, Your Excellency?
Can you address that now?
Okay. Thank you so much, Your Excellency. So, it is argumented by the applicant state that it's self-defense. It is self-defense that self-defense that exercised by the applicant state was under Article 51 of the UN Charter, and if I may state it that in the UN Charter Article 51, it is stated that if the attack was occur, and according to Article 31 of the VCLT, the Vienna Convention Law of Treaties, it is stated that any treaty should be confined in a good faith, and the treaty should be forgive me, Your Excellency, in accordance with Article 31, Paragraph 1 of the VCLT, which mandates the interpretation of treaties in good faith and in line with the ordinary meaning of their terms. Within the context, it becomes evident that Article 51 leaves no room for ambiguity. The language used explicitly limits the right of self-defense to instances where there has been an attack by a state and cannot be interpreted otherwise. Therefore, we respectfully request the court to reject the applicant's argument concerning the right of preemptive self-defense, as it contradicts the clear and unambiguous language of Article 51. May I proceed with my pleading, Your Excellency?
Sorry, I don't quite get your argument. I mean,
Okay.
factually, they are saying that they are doing an act of self-defense because your country is developing nuclear missile. And the Learned Council also say that developing a nuclear missile is not allowed under international law. And the fact that you're creating it is creating a threat to everybody. And they're acting preemptive self-defense to stop the further development. So, and therefore they are right to attack you first. And what is your response to that?
Okay, Your Excellency, we respond that the act of the preemptive self-defense acted by the applicant state is not justifiable, since in order for inherent it to exercise its self-defense, it needs to be an attack occurs first. Then the injury state shall be inherent the right to exercise self-defense. However, in the Moot problem, it doesn't comply that the provinces of Roxana attack first So then the Article 51 that was brought by the applicant state is not justifiable since there was no attack occurs at first, Your Excellency.
No, yeah, okay. And then the question is, what is the law that says that there must be an attack first before you can invoke self-defense? And because if that is the case, then what's the point of saying preemptive self-defense? Preemptive self-defense meaning there is no attack on you first and you preempted it. So I want you to clarify on me the laws on that.
I'm so sorry, Your Excellency. Can you repeat your question, please?
Okay. I want you to clarify because you say that there must be an attack first before you can invoke self-defense. So where is the law that says that? And if that is the case, then what is the meaning of preemptive self-defense, which must mean that you are self-defense without somebody attacking you first? Is there such thing as preemptive self-defense? And can't you say that they're acting on preemptive self-defense?
Give me a second, Your Excellency, to conclude my answer. Your Excellencies, even though the act of preemptive self-defense was was sorry was 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 stated that there is no existing law that justify preemptive self-defense, Your Excellency, and hereby the act of self-defense conducted by the Azura was not cannot be justified, Your Excellency.
Okay, proceed. Thank you.
Going to our next sub-argument, we stipulated that the attacks cannot be justified as self-defense. In Article 51, forgive me, Your Excellency. Going next to our next sub-argument, we stipulated that the attacks were not proportionate, Your Excellency. In Article 51, paragraph 5.b of Additional Protocol 1 of the Geneva Convention, it stated that proportionality must not result in loss of civilian lives and injury to civilians. In the NATO bombing campaign, the attack on the Chinese embassy resulted in loss of lives of 3 citizens near the building, and it is a violation to international humanitarian law for being excessive. Relating to the current case, Azura's multi-pronged attack also resulted in loss of civilians. If I may refer you to Annex D of the Moot problem, it is stated that United Provinces, not United Republic of Azura, which has resulted in widespread destruction and loss of life on our territory, and hereby the attack was not proportionate, Your Excellency. And entering our last sub-argument, Your Excellency, we stipulated that the attacks were not necessary. In the Nicaragua case, it stated that self-defense applies if it's necessary to respond to. Here, Roxana did not pose any attack towards Azura's territory. However, Azura kept on launching its military attack and tried to justify it as self-defense. Entering our second major argument, the Republic of Azura must pay for compensation for the injuries suffered for 3 reasons, Your Excellency. Firstly, Azura attacks is a breach of international obligation. In Article 21 of the Article on Responsibility of Wrongful Act, or RCWA, stated that the wrongfulness of an act of a state is precluded if the act constitutes a lawful measure of self-defense taken in conformity of the Charter of the United Nations. Azura action here is violating Article 2, Paragraph 4 of the United Nations Charter for using its force to give serious threat to the respondent state territorial integrity. And going on to our second sub-argument, Roxana is due to the multi-pronged attack done by the applicant state. Roxana has become an injured state. An injured state is a state whose legal right has been infringed by the wrongful act of another state. Due to the action, Roxana has become an injured state and has the right to ask for reparation from the applicant state. And lastly, Your Excellency, we submitted that the Azura obligated to compensate. It is well established in established rule of international law that an injured state is entitled to obtain compensation from the state which has committed an internationally wrongful act for the damage caused by it. In the case of Corfu Channel, Albania has obligated to pay for compensate to the United Kingdom for breaching its obligation to international law. In the current case, due to the act of Azura violating international law and making Roxana an injured state, thus, Azura must pay to compensate. If this court has no more inquiries, may it please the court.
Last question. Just answer me this question. If in a situation whereby both countries are at fault in attacking each other, is there any case laws or laws on explain how reparation should be awarded?
I'm so sorry, Your Excellency, your voice was breaking up. Can you repeat your question, please?
Sure. I mean, I just want to ask if the situation where both countries are at fault, both countries are wrong in attacking each other and engaging in warfare, is there any case law or laws to say how then reparation should be awarded when both are wrong at the same time?
Give me a second to conclude my answer, Your Excellency. If the court somehow found that both of the parties has an injured during the warfare, it is must that both of the parties should prepare or repair for the injury, which is to compensate or to restitute, compensate or satisfy to the injury that has been conducted to the state that are injured at the moment, Your Excellency.
So both have to compensate each other.
Yes, Your Excellency. For example, it is in the Gapchikov Najimaros when the court declared that Slovakia and Hungary have to pay each other to for the wrongful act that they did.
Okay, thank you.
Thank you so much, Mr. President.
Okay, Junior Counsel, whenever you are ready. Unmute.
Am I audible? Thank you. Good morning, Mr. President, Your Excellency, may it please the court. As introduced by co-counsel, my name is Nazal, appearing on behalf of the provinces of Roxana as a respondent before this court. For the next 17 minutes, I will be addressing the final submissions of the responding concerning United Provinces of Roxana acted in accordance with international law interrogating Octagon with its hypersonic nuclear missile and did not need to pay reparations to Republic of Azura for the damage occurred. If this court has no preliminary inquiries, we would like to continue with the respondent submissions. Mr. President, Your Excellency, may it please the court. The United Provinces of Roxana, acting as the responding party under this proceeding, would like to provide our defense argumentations against the failed lawsuit from the Azura. As we already hear from the applicant's pleading, they raise the objections to our actions in deploying our nuclear missile. Hereby, throughout this proceeding, we would like to show you justifications behind its deployment. Being that said, respondent raised two claims. Firstly, United Provinces of Oksana acted in accordance with international law interrogating Octagon with its hypersonic nuclear missile. Second, United Provinces of Oksana need not pay reparations to Republic of Azura for damage suffered. Your Excellency, moving to the claims and to the next would be called as the main argumentations. We submit that United Provinces of Oksana acted in accordance with international law, interrogating Octagon with its hypersonic nuclear missile. There are two sub-argumentations here. First, Roxana acted in accordance to the Charter. The Charter is the most fundamental yet crucial international legal framework. Under the Charter, it is obeyed by all states to act in accordance with the Charter itself. Throughout these argumentations, there are two reasons why why Roxana acted accordance with the Charter itself. First, Roxana acted as a form of self-defense, which was in line with the necessity principle. Under the Article 51 of the Charter, it is deemed necessary to act as the measures of self-defense to restore international security. However, such a self-defense would adhere to the common international legal principle of proportionality and necessity. Roxana acted to respond to constant strikes from the Azura with its proportionality due to the fact that it is the last resort of the dispute resolutions. Second reasons why Roxana did not violate the principle of non-use of force. Respondents are aware that the launch of hypersonic nuclear missiles is a part of use of force which is prohibited under the Charter and being emphasized by the UNGA resolutions. However, Your Excellency, there is an exception to that prohibitions if the use of force acted as a form of self-defense. In fact, the attack using hypersonic nuclear missiles by a respondent was in self-defense from the strikes conducted by Azura against respondent's territory. Thus, it is deemed necessary to respond to strikes of Azura through self-defense. Second, sub-argumentations. It is lawful under international humanitarian law. There are three reasons. First, it is justifiable under international humanitarian law because the object of attack is military objective. Under the IHL, an object must fulfill two elements to be determined as military objectives. First, it must have effective contributions. Second, it gives military advantage. Referring to the ICRC commentaries, military advantage is limited to the measures for ground gaining and weakening the enemy's armed force. In the present case, the Octagon, as the object of nuclear missile launch, is a place of military command and control center as the nerve which respondents consider as the part of military effective contributions of Azura military operations, which prove that there is adequate effective contributions made by Octagon itself. So, targeting the Octagon would give the definite military advantage. And in conclusions, a nuclear missile launch targeting the Octagon is lawful. Second reason why it is in accordance with international humanitarian law. The attack and the usage of hypersonic nuclear missiles are lawful to the principle of distinctions, and we already have done the precautions in attack. According to the Article 51, paragraph 4 of additional protocol in Geneva Conventions, there are several prerequisites in determining its weapon as an indiscriminate attack, which address to the violations of principle of distinctions. First, inability to separate military objective and civilian object. Second, the military advantage is excessive. The third, there are two prerequisites. However, as a part of precautions, which required through Article 57, paragraph 2 of Geneva Conventions, additional protocol 1, the Roxana has done several measures to assure that the launch such as Roxana has done several measures as the part of precautions itself. For example, assure that the launch of such nuclear missile directly targeting exact to the Octagon as a military objective, and we do increasing the likelihood of successful snatching the target of the strike itself. Hence, the attack using hypersonic nuclear missiles is still in accordance with the principle of distinctions itself. Third reason why it is in line with the international humanitarian law. The collateral damage caused to the civilian is the wrongfulness of the Azura itself. The collateral damage occurred as a part of Azura wrongfulness in acting unlawful toward the Rule 23 of the customary international humanitarian law, which stated that the state must avoid locating military objective closely to the civilian. In the present case, Azura put the command and control center in the heart of the capital city. Therefore, the damage occurred to the civilians as a result of the Roxana's wrongfulness to the customary international humanitarian law. Moving to the second main argumentations, United Provinces of Roxana need not pay any reparations to Republic of Azura for the damage suffered.
Agent, am I audible to you?
Yes, you're audible, Your Excellency.
Yes, I have a question before you move on to your next submission. I believe you heard the second applicant to make contentions on your nuclear use that would harm the environment. Do you have any justification for that?
Your Excellency, yes, we are aware that in fact, and also in clarifications, it stated that the effect and the explosions of nuclear missiles, it can directly affect to the environment itself. But as I stated before, as the justifications in our nuclear launch itself, because it is last resort for us to do this, because there are the earlier strikes conducted by Azura itself. They are attacking our troops itself, and it is hurts, and it is our dignity as the country who are focusing on the military itself, while in protecting our sovereignty, as it also the proposed as it proposes when we are developing our nuclear missile to protect our sovereignty. So it is a great time, and it is a proper time to launch our nuclear missiles as a last resort for us as the Roxana itself. Moving to the second main argumentations.
Sorry, Counsel.
Yes.
So you are saying that because of the attacks that Azura has done on you, it is proportionate for you to launch a nuclear missile, which has effects not that is targeted at the capital city of Azura, which affects 8 million civilians and can even affect the environment and have long-lasting effects on the environment, and that you say that that is proportionate.
Your Excellency, we are still considered that it is proportionate under the international humanitarian law, because we already do precautions in attack. We assure that we are targeting directly to the military objective itself. Even though we are having a collateral damage occur to the civilians, as I stated before, it is wrongfulness under the customary international humanitarian law when a state must not put the military objective closely to the civilian populations. So it is the wrongfulness conducted by Azura itself.
Okay, so that's I got one more question. Is that the fact that you are able to use your nuclear missile and hit the Autogon, the capital city of the Azura, does that not specifically exactly justify their perceived threat in the first place? They say that we had to act in preemptive self-defense because your weapon can damage and can reach our capital city. And you, in launching this attack, prove exactly the point that they were right to attack you first, because the weapon that you developed can in fact, as proven by yourself, affect their capital city and cause huge damage to them.
Your Excellency, to be clear, and it is directly attacking to the argumentations conducted by applicants, we must to take notice that there is no any court judgment and justifications on preemptive self-defense itself. Even in any court, there is no court that accepting the reasoning of preemptive self-defense itself. So there is no justifications behind and legal a basis on their argumentations as the Azura to doing preemptive self-defense itself. However, they are also not clear in defining which of threats that they are afraid for, because we are conducting it. We are already clarified through our social media, through our official statement by the state, that we are conducting these nuclear missiles as a part of us to protect our sovereignty. And because we are, as the country who are focusing in military objective, this is our dignity for having a strongest weapon itself. And there is no have any bad intentions to the other neighborhoods countries.
Okay, maybe applicant can address this later. Okay, thank you. Continue.
Thank you so much, Your Excellency. Moving to first reason why, as the first sub-argumentations in supporting why there is no our country no need to pay any reparations, because Roxana nuclear missile launch did not constitute as an international wrongful act. In classifying this, there are two elements. First, it is attributions under the state. Second, there is a breach of international obligations. It is true that the nuclear missile launch is done by Roxana itself at the state, so it is attributable under the state, and it is fulfilled the first element of the Article 2 of RCWA. However, regarding to the second element, commentary of Article 2 of RCWA elaborates where an international obligations might arise from, and it is provisions stipulated in a treaty or bilateral obligations. The fact that there is no any treaty or bilateral obligations from any agreements that binds both applicants and respondent, it makes the respondent did not fulfill the second element, which is breach of international obligations. Regarding this, as it has been elaborated under RCWA that these rules are cumulative, so the absence of second elements of this rule make the actions conducted by Roxana cannot be claimed as international wrongful act. Second reason why we don't need to pay any reparations, because Roxana is not a responsible state. Referring to Article 1st of RCWA, it implies that every international wrongful act of a state entitles the international responsibility of the state. As it not proven that Roxana constituted international wrongful act through the previous argumentations, therefore, Roxana does not adhere to the title of responsibility state. For instance, the act of Roxana is the form of collective, as the form of self-defense in responding the earlier strikes committed by Azura to our territory repeatedly. So, the Roxana is supposedly entitled the injury state rather than responsibility state. Third reason why we don't need to pay reparations, because Roxana, that's the reasons of Roxana no need to pay in reparations, because under Article 31 of RCWA, it ruled that the reparations has two elements. First, conducted by responsible state. Second, must repair any occurred damage. That is because it has been refuted through the previous sub-argumentations, such as A, Roxana did not constitute international wrongful act. Second, Roxana is not a responsible state. Hence, Roxana no need to pay any reparations. To conclude our submissions, we submit that United Provinces of Roxana acted in accordance with international law in targeting Octagon with its hypersonic nuclear missiles and did not need to pay any reparations of Republic of Azura for the damage suffered. Thank you, Your Excellency, Mr. President. May it please the court.
Okay, thank you. Can I know how much time is left? How much time is not utilized?
There's 2 minutes left, 2 minutes and 14 seconds.
Okay. We can proceed with the third rebuttal, but I'm just wondering if the third judge is still in. And
Sorry to interrupt. So Ms. Burush will not be joining us for this round.
oh, but it's so we can proceed, huh?
Yes.
Okay. 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 With no problem, then we can proceed to rebuttals.
Your Excellencies, me as a co-counsel, Michelle Zulkifli, will submit two rebuttals, which mainly the first one is the act of proportionality under self-defense, which is according to the Article 51 of the United Nations Charter. And the second one is um, the fact or the meaning of minimize civilian casualties in Annex D mentioned by the respondent just now. Your Excellencies, according to the first submission, which includes the proportionality and the doctrine of self-defense. If we compare the proportionality between Azura and Roxana, I direct you to the Moot problem, page 11, paragraph 20. Azura's attacked Roxana only utilizing its air, land, and naval forces, while I direct you again to the Moot problem, page 16, paragraph 17, where Roxana attacked Azura, which suffers their environmental pollution, as can be supported in clarification question 4. So between these cases, Azura suffered more damages than Roxana. In this case, the act of proportionality uh, cannot be defined in this case. Additionally, Roxana's development of nuclear weapon has violated Article 2 of the Non-Proliferation Nuclear Weapon. Therefore, we submit that the doctrine of self-defense is not applicable in the case of Roxana. Your Excellencies, as for our second point, just now respondent mentioned about Annex D, and also respondent also says that it has minimized civilian casualties. However, I direct you to the Moot problem, page 11, paragraph 20. No casualties reported when the Azuras attacked Roxana. It only says, I mention again, it only utilizing its air, land, and naval forces. No casualties is reported. Therefore, we submit that the evidence used by respondent is not valid in this case. Thank you for your attention. That's all for our rebuttals.
Okay. Sorry about that.
Hello, am I audible? Hereby, the professors of Roxana, as the respondent on these proceedings, will deliver its rebuttal. The attack that was conducted by the applicant state, in which was explained by the agent of the applicant state, it is mentioned that the attack was proportionate since the attack only targeting the military target. However, if I may refer you to paragraph 26, paragraph 25 of the statement of agreed facts, it is stated that the Council also expressed concern over the potential violation of international humanitarian law, including the targeting of civilian infrastructure and indiscriminate use of force by the Azura. And if I may refer you again to Annex D, Annex D of the statement of agreed facts, it is stated that there was a loss of life on Roxana territory. Hereby, the attack was not proportionate and it is excessive. And then the applicant state submitted that the NPT brought the non-proliferation treaty in this submission. However, the NPT cannot be accepted as a legal basis because not both parties are ratified to this treaty, so it is not legally binding. Thank you so much, Your Excellency. Mr. President, may it please the court.
Okay, thank you, Council. Bailiff.
So, Your Excellencies, that concludes the round. We will now adjourn to the deliberation room for further proceedings. Please wait a moment.
Thank you, Your Excellencies. Thank you, applicants.
Thank you so much.
Thank you.
Thank you.
I'll just use the washroom first. Sorry.
Wait a moment.
Sorry to interrupt. Angel, are you assigning the breakout rooms? I can't hear you. Can you give me a thumbs up?
Hello?
Okay, I can hear you now. Sorry. uh, you may assign the participants to the breakout rooms.
Going to do it. Please wait a moment. Okay. All right. So, Your Excellencies, please note that we have up to 15 to 20 minutes for you to complete your score sheets. So, kindly score the participants' performance based on the provided criteria. And once completed, please email the score sheet back to the organizer at competitionilsa.com.my. And please take your time to deliberate and complete the score sheet. Should you have any question or require any assistance, please contact us.
Thank you very much. Angelica, I think I have not been able to note the team number for the applicant team. Would you please assist me with that?
Please wait a moment.
Hello, tolong buang Nazar out.
Sorry, can you assign to the breakout room?
Wait a moment.
We have Nazal, please enter the breakout room.
Already assigned. Okay.
Did we get the number for the respondent, the applicant team?
I think applicant is 1001A, right? Is it correct?
Okay, and the respondent is 1004, right?
Yeah, I think so. Correct. Bailey.
Okay. So hello, Mr. Louis. If I'm not
Hello. Yeah, I didn't get to say hi yet just now.
see you,
Nice to
and
meet you.
same here. It was an honor to share the panel with you. I really like the questions that you asked.
A
I
pleasure.
think they were very constructive. So I would like to just share my points, my thoughts on the participants. First applicant, I think he was good but very nervous. I found him to be, and I did not find him to be very well prepared. I think I'm not sure if it's his first time mooting. I'm not sure. The second applicant, I really found her impressive in terms of composition and calmness, and I didn't find her nervous, and she was I mean answering the questions pretty well. In terms of the respondent, I'm not, because this is online, it's difficult to understand whether they're eye contacting with us or they're reading scripts or whatever that is happening. So I wouldn't go there. But the second respondent was better to me. I think he did really well in terms of explaining the facts and relating the facts to the laws as well as addressing the questions. So I'm still not sure which team should win. I'm not sure whether we should decide which team should win in this particular session, but this is my thought on the teams, and I would also provide the written feedbacks in the feedback form. I would like to hear from you.
Yeah, I totally agree with your assessment. I also think that the second counsel for both teams are better than their first counsel. I'm a bit surprised that the rebuttals for the respondent came from the first counsel when I thought the second counsel should be handling the rebuttals, because he's clearly so much more familiar with the facts, and I can see that when he answered the questions, he answered impromptu. It's like, okay, I just know what to answer. I know what the facts are. But yeah, I mean, if I have to say, I think the respondents slightly edged out a little bit, because the first applicant is quite weak and didn't even actually answer the question. And he was clearly just reading from the script, and once questions is asked, he totally lost it. So a bit unfortunate for the second applicant, but I mean, team-wise, I think respondent is slightly better. I don't think we don't need to tell them the winner, right, I believe, and we just have to score and give feedback only, right?
Yes, we will announce it later.
Okay, then I guess we will just score, and then later we take turns, whether Tazi want to go first or I go first, and give the feedback.
Okay, and Angelica, do we have to, will they come back for the feedback session, or do we have to just provide the lecture sheets, I mean the score sheet, and then leave the team?
I think we will just provide feedback to them.
They will come back, right?
Will they come back?
Yes.
Okay. Because I'm too lazy to write everything.
I'm so sorry, I didn't understand. Umasri, are we supposed to give feedback to the participants when they come back to this room, or just
when they come back to this room?
Okay, all right.
Okay, because
Mr. Louis, can I just confirm? You will be completing the score sheets later.
I will do the score sheets now, but I'm too lazy to write my feedback in the score sheet. So I will just.
I like my feedbacks written.
I just give it orally later, and I give the scores.
Okay, all right, sure. So you will have to email the score sheets back to the organizers via competition@ilsauniza.my.
So Umasri, can I send it after the session, maybe?
Sure. Please do send it immediately after. Thank you. So Angel, you may add the participants back into the room.
All right.
Give me 5 more.
Okay.
All right, sure.
Bailiffs, very well done. You're doing very well. Don't be nervous. Whatever happens, it's just a technical glitch. It's fine.
Thank you.
Thank you.
How many total teams are participating this time?
There are 4 teams. Originally there are 16, but 2 resigned, so there's only 4 teams.
Is it between different universities or just one university?
It's actually international one.
Oh, okay.
Internal one. There's also from the other universities.
Oh, very good.
Sorry, each item is up to 20 marks, right? So 5 times 20, 100, right?
Sorry?
Each the score, each item is knowledge of the law, each is up to 20 marks or
Yes, yes, yes.
Okay,
That's
okay.
what I understand by the yes.
So total 100. Okay, thanks.
Sorry to interrupt. Please do let us know once you have completed the score sheets. All right.
Okay, thanks, Ken. Can proceed.
Thank you. I think we can proceed to the next stage.
All right, just wait a moment.
Aku scared.
Sorry to interrupt. I believe Angel is having difficulties with her microphone. So judges, you may begin giving them feedbacks to the participants.
Okay, Taraji, would you like to go first or you want me to go first?
I only have a very few points, so I would leave the details for Mr. Louis to complete. First of all, thank you very, very much for this session. It was wonderful to hear from you. I think the issue is pretty complicated. There can be several arguments that you can make. I really like how you chose to prioritize your arguments. In terms of individual feedback, I'm not sure if I should mention many, but for the first applicant, I think you have good research and good elements to provide, but I think you should be a little more not nervous. I think you should be a little more confident and be in your comfort zone. And also, when you seek for extra time or whenever a judge is asking you a question, you don't say that, can I please get some time to recollect my thought. You can say that, but that time should not be more than, let's say, 20 seconds, 30 seconds, because during that time the judge gets bored and it's considered to be a waste of the time of the court. So that might intimidate the other judges, and it basically disrupts the proceeding. For in terms of the second applicant, you were a fantastic speaker. I really like the enthusiasm that you have and the energy that you demonstrate. It was fantastic. I think when you did the rebuttal for your team, you could have, I think for a rebuttal, one point is very important, that when you come for rebuttal, you say that I have this many points for rebuttal. And you make it very clear that I have 2 points or 3 points or 1 point. And when you say that, you do not do sub points in your points. I believe you had 2 points, and in your first point then you had several other points. That makes me quite confused, because I thought you were giving your second point, then you're like, no, I'm moving on to my second point. I'm like, then what was the first one? So I get confused as a judge. So I want you to make it very clear that I have 4 points: one this, two this, three this. Do not make subdivisions. This is my suggestion, that do not make subdivisions in your rebuttal. Other than that, you were good. Respondent one, you were good, but I think you could have been more confident. I think you lacked a little bit of smile. Other than that, your research was very good, and you did indeed deliver well. Respondent two, very well, very energetic, and I think you have a very good way of answering the questions. I'm not sure how you would have done if you did the survey battle, but I think for the submission you did well. And a survey battle, respondent one, you did very well in terms of survey battle. But I think when you do survey battle, you have to make it very specific what you are answering to the rebuttal, and to which point, what argument you're making. You do not repeat what you already said in the submission, because we've already heard that. Now we want something else. And also for both teams, in terms of rebuttal, survey battle, during the rebuttal, the judges basically wait for something very spicy, very chilly, something that we haven't heard. The team will come and crack the other team. But when you say that, may I please drive your attention to this paragraph, I'm not going to open the fact sheet during rebuttal, because when you conclude your submission, the main submission, I basically close the files and wait for you to fight now. So I'm not going to open it back and see what is written in paragraph 6, because the agent is saying paragraph 6. You just say that it is in the paragraph 6, whatever that is, but this is what is said. So you do not ask me to basically open the fact sheet. Other than that, I think both of the teams did well. My very best wishes for both of you, and very well done. Thank you. I think I would now move the floor to Mr. Luis.
Okay. Thank you very much, Tarazi. I agree with what all her feedback. So please do take notes and try to absorb them and internalize them and improve of these fact points that Tarazi raised earlier in your next session. Also, I echo Tarazi and say that all of you have put in great effort. I can see that. So congratulations on that. Congratulations on having the courage to join and putting the effort in preparing on this event. I will tell you that in real life, in practice, that you won't get after you perform or submitted in court. You will just have a decision to your case, but the judge won't sit down and tell you, okay, what you can do better, what you cannot do better. You will not have that anymore after you leave university. So appreciate every chance that you get in the university time where you join competitions, where you can actually get feedback for your performance. And also that also means that you must take in the feedback, write that down, internalize them, read them again before your next round, so you don't make the same mistakes. If you keep making the same mistakes and get the same feedback, then there's no improvement. It's a waste of time. Whereas if you internalize it, you don't make the same mistakes, you make new mistakes, then you have a chance to continuously improve and build on your skill set. Okay, so I do hope that you take our feedback seriously and try to use that in your upcoming sessions. Okay, now, I think I will avoid going to each individual because otherwise it will be too long. But just bear in mind that whatever I say, it's still applicable to everyone. Some of you have done it, so just keep doing it. If some of you have not done it, please try to look at yourself and maybe work on it the next time. Okay, I think generally all of you. Firstly, technical issues. I don't understand why appellant takes so long to get prepared. That is, applicant takes so long to get prepared. It's unacceptable. I know sometimes technical issue happens, but the other side, the respondents were prepared. So Why is that an issue with only with the applicants? And in the virtual hearings, all these things will happen, so you must be prepared to and not just blame it on the technology all the time. Okay, so that is unavoidable. And I prefer the setup by the respondents. You can see the whole body, the face, the shoulders. You can see it's facing it, as opposed to the screen being too near, or that you can see that you're looking at somewhere else. I know these are all new things that only happens in virtual hearing, but it's still something that we can work on, we can perfect. Okay, have a good microphone, have a good screen, have a good network, have a good structure, so that the judge can focus on your submission and not get distracted by all this nonsense. And then you frustrate the judge, and you also lose their focus. Okay, so that's the simple things that we can work on. In terms of command of the language, in terms of pronunciation, in terms of pace, voice projection, I think all of you have no problems. Okay, I'm very pleased to see that all of you can speak English quite well and can articulate your thoughts quite well. Then the question is just the issue of your arguments. Now, one key issue that you need to first, very important point that you work on is to really look into the moot question and see what is the key make or break issue of the case. Okay, what is the key issue, key arguments on the place, and then elaborate and develop your arguments based on the key issue. So for the first, for example, the main issue is whether there is such thing as preemptive self-defense. You attack somebody on the claim that I attack you because I'm preemptive self-defense. So whether there is an attack or not, whether that amounts to an attack or not, that is not a key issue. That is already, everybody understand there is an attack. And there is an attack when there is no, it was not initiated by Rosanna. We all know that those are facts. Don't need to submit on that already. Or even when submit very briefly. Focus on the key issue. Yes, there's an attack, but is it justified because of such thing as preemptive self-defense? That is the key point. So focus on that. So that happens in real life a lot, because a lot of times judges already form an opinion that you have 3 points. The first 2 points, I either accepted it or I already don't accept it already. So I would ask you to go to your third point. At that juncture, you should sense that the judge is more concerned of the third point, and that if you can persuade him on the third point, you will win the case. So you go straight into the third point and focus on tackling the third point. You don't say that I have arguments, but I will address it later. If there is a specific situation whereby you must explain first point before you can go to third point, then fair enough. You say that, my lord, I understand your concern on the third point. My short answer to the third point is yes, because this is, but my lord, for me to explain to you clearly on my third point, I need to elaborate slightly on my first point first. When you explain that, the judge, okay, fine, I will let you explain. But if you tell judge, I haven't gone there yet, I'm still at my first point, the judge will be like, I'm asking you now, please just answer me. I want to be persuaded on this point. Otherwise, even if you submit on the first point, I won't be listening to you, because I'm still concerned about the third point. Okay. Identify key issues, focus on key issues, and also when judges ask you to focus on a certain point, go to that point. Okay. Persuade the judge, because you are not here to run a script. I know you have prepared a script, you want to run through it, but that's not your job as an advocate. You're not a job as a counsel. You're not here to read a script. You're not a public speaker. You are here to convince the judge. So the judge wants to be convinced or explain on which point, you persuade him on that point, not stick to your script. Okay. So last time when I was younger, the practice that I used to do is that I have a cut of 3. I always focus on 3 main points I want to deliver, because I know if I cannot convince my judge on 3 strongest points, my 4th point, 5th point, 6th point has no meaning. So I focus on my 3 strongest points. And then what I do is that I will have small cuts of each point, and then I shuffle it, and then I open the first point, I submit on that point, whatever the order is. And then I close it, I open the second cut, whatever the second cut is, I flow from that first point to the second point. So I can always, then I shuffle again and I change the order. So I can always flow from which point to which point. I'm flexible. I'm not bound by a script, because I know at the end of the day, I only got 3 points. So I can start with the third point, continue the first point, start with the second point, continue the third point. I can flow, because I know what is important for me is to persuade the judge, and what he wants to hear, you tell him what's. You don't stick to it. So like some of you, I know you prepare a script. So I purposely ask a question, or purposely ask you to go to the third point. And suddenly you're, I don't know what to say already. I'm so lost. My lord, at first very smooth, and suddenly all gone. Okay, because you're not prepared for that. Okay, so that first point, focus on key issues. Second, answer the judges, persuade the judges on what they want to hear. Third, be very flexible, be prepared to be flexible. And fourth point is to critically analyze your own arguments. Okay, what we call critical thinking. Critical thinking meaning you look at a certain point and you think from many, many angles. So I think I want to make this argument. Okay, but if I make this argument, what will the judge ask me on? If I make this argument, what will my opponent argue on this? What is my counter argument to the argument? What would be the counter argument to my argument? What would be the counter argument? This is why it's called critical thinking. Okay, so you all cannot think of a point you think is very smart, then okay, I will deliver it. But when it goes to court, judges start throwing questions at you, start questioning your argument, opponents start countering argument, you have no answers. It cannot be that case. So you must properly critically analyze each point and then be prepared. You in critical analyzing, you would have prepared or anticipated, preempted is what I use, preempted the questions that the judge or the opponent will throw at you, and you will be ready to answer them. Okay. So the questions that I ask you are not because this is a moot, so I need to press you, train you. No. I ask you because there is the gap in your argument. You say this and doesn't make sense, but how do you explain this? What do you have to say about this? The other side say this. It just comes naturally because I want to be persuaded by you. So some of you, when you are able, I think the second counsel for both teams, you all perform quite well in terms of answering questions. I'm very pleased with that. Congratulations on that. When you all are able to answer my questions, persuade me on those questions, that's when I'm persuaded. You reading your script doesn't persuade me. But when I got a question, you can answer, oh no, there's no such thing as preemptive defense. Or yes, it's military object, but when it involves so many civilians, it cannot be a military object. Yes, it's a military object, but once it's their own fault to put the military object in the city center. Those are questions that we have, and those are questions that you're able to answer. That's when we are persuaded. And we're, oh, okay, makes sense. Okay, I can agree with you. But just reading your script doesn't do the persuading. So you must critically think. You must anticipate questions that is asked to you. Okay, I think I've given you 4 points. Maybe one last point, I think, is just give you one more important point. Okay. One last point is just is a bit similar to my earlier point, which is you are there to have a conversation with the judges. Okay, you are there to persuade the judges. You are not there to read a script to the judges. So don't talk to the judge or talk on to your judge. You talk with your judge. Okay, you have a conversation with your judge. So when judges ask questions, it's not something to like be scared or be upset or like, oh, you throw my flow off or you waste my time. No, you'll be very happy because when they ask you questions, it's the opportunity for you to show your advocacy, your ability to persuade. Okay, so you have a conversation. So a lot of times when I go to court, it's just as how I talk to my boss. My boss, oh, okay, this is how we want to argue it. Then he ask me questions, then I have a conversation with him. They'll do exactly the same thing in court. Judges also like that. Oh, okay, but that is like that. But that was the argument that I answer that. Of course, when I say I'm not talking out of thin air, whatever I think, I feel, I believe, no. What I say is based on this authority, this is my submission. Based on these facts, the facts apply to this authority, this should be the conclusion. So it's still based on authorities and facts. Okay. But then you are having a conversation and trying to persuade. Okay. So you must be able to do that. Okay, that is, I mean, there are other points. Feel free to connect with me on social media. I'm on LinkedIn, Instagram, everything. Feel free to connect with me. We can have talk later. But otherwise, congratulations, and I wish you all the best. And again, thank you very much to Tarazi, and unfortunately, the third judge as well. It's been a pleasure. And okay, all the best to all of you. Thank you to the organizers and the bailiffs and the technical support as well.
Thank you, Mr. Luis. I would, on behalf of ILSA UniSZA, we apologize for any technical issues that we face. So, Angel, we can conclude this round. So, again, her microphone is... yeah, we're unable to hear you, Angel. So with that, we end this round here. Thank you very much, judges. Thank you, participants, for joining.
Take picture, right? Okay.
Ismahani, have you taken the photos? All right, so our technical support has taken the photos.
Okay, thank you.
All right.
Thank you very much, everybody. Thank you.
Thank you. Bye-bye.
Thank you, everyone.
Thank you very much.
When are we going to take picture?
Dah habis dah.
Allah. Okay. Okay lah, bye. Thank you.
Bye, Risha. Congratulations, you guys.
Thank you. Bye-bye. Take care.
Okay, Angel and Ismahani, please wait here.
You hear me? Hello? 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 Hello?
Muhammad Ahsan. You can live right now. Okay.
Boleh dengar kah?
Boleh,
Hello?
boleh,
Hello?
boleh. Hello, yes,
Boleh?
yes. Hi, hi, hi. Clear, clear, clear.
Why? Dah jalan.
No,
Dah tak
I can
tahu apa
listen
jadi.
clearly, but sometimes it was like macam suddenly gone. Something like that. Suddenly you gone.
Jangan marah. Bagus. Like we're not the for no.
You nak record lagi ke?
Shoot.
Stop again. Stop, stop.